It's very heartening to see this interaction or this session, and it's a physical session and not a virtual session. Last 2 years, the physical bonding when people sit in a group, the energy level is much higher. The interaction of ideas is much better. Now, this session, I would call it, is the heart of mediation. And why is the heart of mediation? People come to court for litigation, each having their own rights, each having their own point, and they say, in law, I am entitled to X. And when this concept of mediation started, most of us looked at as a failure of our justice delivery system, that the delay in getting justice is what making people to accept lesser than what they are entitled to. And this is how this concept started. And that's how it continued. I saw this happen practically in the Supreme Court. Once Justice Kurian Joseph was in court number 5, a matrimonial dispute came before him, and it was from Tamil Nadu. And Justice Kurian Joseph thought that I knew Tamil, which I don't. But he said, Prasad, you are there, why don't you sit with them and solve the issue? So I was amazed and I was scared, but in any case, we went to the consultation room of the Supreme Court. And in 15 minutes flat, I was out of my wits. I did not know what has hit me, because both sides were showering abuse against each other. And I did not know what to do, and I did not want to go back to the court in 20 minutes and said, sir, I failed. So I called a mediator friend of mine to come and say, I am stuck, what do I do? This friend came into the room, the consultation room, and I later on realized it was something called as an opening statement which was made. The effect of this statement was, to a great level, as ma'am said, confidence building. That statement brought out that she is neutral. That statement brought out that what is happening in the room remains in the room and does not go to the court. That statement brought out that she is not a judge, but a facilitator. That statement brought out that it is up to you to reconcile, to come to a solution or not come to a solution, and that it was not a scare that, look here, it will take so much of time in the court and therefore please settle. No, it was, you tried to bring out a solution amongst yourself. That statement really instilled a lot of confidence amongst both the parties. And then when it started, both parties, as they told me, started showering abuses. The mediator heard both sides very peacefully and then asked them to go out. So when I asked the mediator, now what? She said, look here, this is just the tip of the iceberg. What has now been ranted by both sides are what they think their cases, what their lawyer has advised their cases, and that they don't want to let go of what they have in order to sort of tell the other side, look here, I have a good case in law and I shall win. Then both parties were called individually and they were asked to narrate their side of the story. The stories were narrated. I could see the mediator sieving necessary and irrelevant information. Then she rephrased what was told to her as to, is this what you are trying to say? That rephrasing again gave a message, yes, probably this is what I want, which actually went scaling down from where they started to where they reached. After they rephrased, this also gave certain amount of lamps that there could be a bit of solution that can happen. The same exercise was done with the other side. And what I appreciated was that the mediator asked one side that when I speak to the other side, am I entitled to reveal this information to the other side or not? Because unless you don't permit me to interact or give this information, I shall not reveal that information. And I found it very fascinating that a permission is being sought from a party as to whether that information can be revealed, because it might become adverse to that party inside the court. That thing started about 12 o'clock, and believe me, it was, by the time it was over, it was 1 a.m. and the parties had not even taken dinner. I could see that in another 11 hours, the parties had come down to such a great extent that they were prepared to talk to each other. And since the parties could come to Supreme Court afford senior counsels, they were rich enough to go to a 5-star hotel to have dinner. And the mediator suggested, why don't both of you go and have a dinner and come back tomorrow. When they came back the next day, the mediator could find that the ice had been broken completely. But they did not jump to a conclusion at that point. The mediator asked, you've come from Tamil Nadu, go back. Think. Come back after 20 days. This thing went on for two trips up and down. And within, say, about 30-35 days, the problem was sorted. The parties did not come back together as husband and wife. No, it ended in a separation. But the separation was extremely well planned. And I am told that the father-in-law and the daughter-in-law share a fantastic relationship after divorce. That is called as journey from acrimony to harmony. Wonderful. Which is the heart of today's topic. And now we will hear the masters of the game to explain the nuances of this game.